Susan to take over from you. Susan?
Welcome to today's webinar, and I apologize that we apparently got started just a tad late, but I certainly am going to stay here as long as necessary to answer any questions that you may have that brought you here to today's webinar. As I go through the presentation here today, it is important that I do my typical disclaimer and that everyone does understand that the presentation and the materials here are for informational purposes only and should not be used as a substitute for legal advice on a particular matter, particularly when we are talking about a law like the Fair Labor Standards Act, and obviously when we deal with people and with their working habits and the like, it is very important that you do get legal advice if you have a particular scenario within your organization where you do need to determine whether you are in compliance with the law or whether you are considering a course of action that may or may not be in compliance with the law. As I said, the Fair Labor Standards Act, it's, we have a lot of litigation and a lot of nuances in the Fair Labor Standards Act, and it's been around for quite some time. It's been around since 1938. The Fair Labor Standards Act was basically passed in response to the Depression. And it was passed to ensure that employers were given what we considered a fair day's wages for work that was being performed by their employees. What we found prior to the Depression was that employers were working their employees in excessive amounts of time, sometimes as much as 60, 70, 80 hours per week, and paying them very, very low wages. And of course, the Depression caused that to occur even more frequently. And this was a measure by which to even the playing field, if you will, where employers would not take advantage of their employees and that they would give them fair wages. And when we talk about the requirements under the Act, an employer is required to pay time and a half for all hours worked over 40 in a work week. And that overtime premium, that time and a half payment, is sometimes referred to as a penalty. It is designed to penalize you, if you will, for working individuals over 40 hours in a work week, but it's also designed to make it where it is costly for you in the sense that it will cost you so much at some point that you would decide to hire another individual to work side by side with that person, if you will, so that you would not, that you would not have to pay these overtime wages. So it had the intended benefit of decreasing the unemployment that was very rampant in our country, during the Depression and shortly after the Depression. So it was a post-Depression remedial statute, and it was designed, as I said, to even that playing field out. With that said, written into this statute is the inherent presumption that given the opportunity, you will, as an employer, always take advantage of your employees. And therefore, it is for that reason that individuals cannot volunteer their time to you. They cannot work off the clock. You must pay for time that an individual works for your organization, whether you have authorized it or not, if you knew or should have known that they were performing that work. So if you get the benefit of their labor, you must pay for it. Now, with regard to working off the clock or working overtime that you have not authorized, it can be a disciplinary issue for you, but it is still something that you have to pay for. So when we talk about what you have to pay for, we always look at terms of, when are your employees working? Obviously, if they're performing certain work for you, that's pretty easy. You've given them instruction to work something, you've given them to do a particular task, they go and perform that task, and that's the easiest of all scenarios. Of course, we never make anything easy in the law, so sometimes it's very difficult to determine when an employee is actually working for you for purposes of determining whether you would have to pay them wages for that particular work that they are working for your organization. So let's just talk a little bit before we get into that working time and how to deal with those employees who do want to work off the clock or work that overtime that you have not authorized. Let's just look at a little bit of the wage and hour trends that we are seeing. Wage and hour claims do represent over 90% of employment class actions that are filed every year. Now, you may think that when we talk about wage and hour claims, you may think, well, we're talking about misclassifications, people who are misclassified as being exempt when they're not really exempt. Now, misclassifications do lend themselves to class actions, and they do lend themselves to a large part of the 90% that you see here. But it's not just misclassifications. It's also about individuals who are working off the clock, or individuals who you are not capturing the time that they're actually working for purposes of determining overtime liability. So that's a pretty high number when we talk about employment class actions. So what we have are wage and hour claims exceed even those claims that are being filed against your organization for discrimination claims and the like. With regard to federal wage and hour lawsuits that have been filed nationally, they have increased more than 400% since 2000, with a record high in 2015 of 8,781 class action lawsuits. These are not individual lawsuits, they're class action lawsuits that are very, very costly to a company. And of course, the larger you are, the more likely you are to see a class action lawsuit. And when you are involved with policies or procedures that you have in place, if you are a nationwide company or the like, these policies and procedures are the things that do lead to class actions if they do violate the law. And of course, the misclassifications, as I said, does lead that frequently. So with regard to employee misclassifications, we are talking about your exempt versus your non-exempt status. Just a brief update on the new white-collar exemption regulation. We know that today, December 1, 2016, was the time that the new salary requirement was going to go into place, where employers would be required to increase the salary from $455 per week to $913 per week to take advantage of the new white-collar exemptions. The Eastern District of Texas, Tuesday of last week, the Eastern District of Texas issued a permanent injunction against those new regulations, and as of about 2 hours ago, the Department of Labor has filed an appeal of that injunction to the Fifth Circuit Court of Appeals. So it is something that you do want to be on the lookout for. Of course, when you have misclassified an individual as being exempt when they're really not exempt, that means that you have not been paying them overtime wages and the like, and that, of course, does lead to a lot of the litigation. Any failure to provide meal or rest breaks, the Fair Labor Standards Act itself does not require an employer to provide meal or rest breaks. That's usually very state-oriented and the like. And, of course, the big-time thing is that the failure to account for off-the-clock work does lead to a large part of these lawsuits that we see here. We also have the expansion of joint employer liability, so keep it in mind when we deal with individuals who you might classify as an independent contractor. If you have classified them as an independent contractor, you're likely not to be paying them overtime wages, and of course, if you have misclassified them as an independent contractor and they're really an employee, you are looking at significant penalties, not just back pay liability, but possibly a lot of tax liability because you have not been withholding taxes and the like. Also, new expansion dealing with franchisor or franchisee relationships and whether there is a joint employment relationship and the like. And keep in mind when we talk about joint employment, you can find yourself in a tricky situation where you may have to add those hours together depending on the scenario for determining whether someone has been working over 40 hours in a work week for purposes of overtime calculation. There's also an increased focus from the Department of Labor on what we call fissured industries. These are industries with high levels of independent contractors and franchisees.